is Ashley Heidemann, founder of JD Advising. In this video series, what we're going to do is cover some of the highly tested essay topics on the Michigan bar exam. So in the last video, we just talked about some highly tested subjects on the Michigan bar exam. But the truth is you have to prepare for any subject to come up on the Michigan bar exam, especially now, because as we just talked about, the Board of Law Examiners has been testing some more of these unusual subjects to see if students can identify the issues. And sometimes it seems like they're trying to trick students or be tricky. So you want to be prepared for what's most likely to come up. So we're going to focus on the highly tested essay topics. And what I'm going to do is just briefly go through subject by subject, give you a couple tips. I'm not going to explain the law in a really detailed manner, but you can download this PDF handout and then hopefully have everything at your disposal. In fact, I recommend that you do that before watching this so you can take notes, because I'll be saying a few things that aren't necessarily in the handout. Okay, so we're just going to start with criminal law, the first highly tested essay subject, and we're going to talk about some of the tested topics within criminal law. The first topic that's tested a lot is homicide. You really want to know the difference between first-degree murder, second-degree murder, and manslaughter. You can see that this is tested pretty consistently, and oftentimes the examiners will have you analyze several different degrees of murder to determine which one the defendant should be charged with. Another highly tested essay topic on the Michigan bar exam is aiding and abetting, or you might learn it as accomplice liability because that's more of the majority term for it, but Michigan calls it aiding and abetting, and I've listed the law here. Basically, this is just something that you want to be familiar with. It's semi-highly tested, and it's a vocab term that you might not have necessarily seen in your commercial course, so I want you to know that Michigan calls it aiding and abetting. And you can see it's been tested pretty consistently throughout the years. Robbery is the last topic that's highly tested on the Michigan bar exam. Remember that in Michigan, robbery is different than common law. So in Michigan, robbery does not require a completed taking, so you don't have to actually get away with the larceny. Common law does require a completed taking. That's one distinction that's been tested. And in Michigan, a person who in the course of committing a larceny uses force or violence against any person who's present or who assaults or puts the person in fear is guilty of robbery. So again, you don't need a completed taking. They like to test that distinction. Just as a warning, if you're looking at really old Michigan bar exam essays, robbery has changed. So if you look at essays from like pre-2004, for example, you might not see this law reflected. But if you look at recent essays, you should see this modern law reflected in them. You should also be familiar with what constitutes armed robbery as well. You can see that this is tested a lot. Basically, anybody who has a weapon or an object capable of causing death or serious bodily injury, or if they lead someone to reasonably believe they have a weapon, or if they just orally or otherwise represent that they have a weapon, then they can be guilty of armed robbery in Michigan. So it's been tested where somebody throws a chair at somebody, that's armed robbery. They have a fake gun, that's armed robbery. They just pretended to have a gun, they said they had a gun, that's armed robbery, even though the person isn't armed. So be aware of that. Lastly, it's not in the handout, but I would look at essays like February 2016. They tested other crimes in February 2016, things that a lot of commercial courses don't necessarily teach, at least to my knowledge. And so some students were thrown off by these types of questions, even though they're really not that hard if you know basic Michigan criminal law. So again, that's February 2016. They tested crimes like fleeing and eluding, felony firearms statute, felon in possession, carrying a concealed weapon, felonious assault, carjacking. And again, these are things that some students just aren't aware of because they're not super familiar with Michigan law. And of course, the board got criticized for testing those issues, but it doesn't mean that they're not going to test them again. So I would take a look at that essay too if you're not familiar with Michigan criminal law. Okay, next let's talk about criminal procedure. One note about criminal procedure is they tend to test fact patterns based on newer case law. So you want to be familiar with recent Michigan cases, recent United States cases. They do test kind of more recent cases for Crim Pro. It's something we're always looking up because we want to make sure that our students excel on any question that tests a recent case. Particularly, they like to test search and seizure. I would make sure that you know the Fourth Amendment and the exceptions like the back of your hand. These have been consistently heavily tested. Same with Miranda rights. You should have a good background on Miranda, know what constitutes a custodial interrogation, be able to define these terms. This has been consistently tested. And then lastly, the confrontation clause. This is considered to be a criminal procedure question or a constitutional law question, not generally an evidence question, although most students learn it when they learn evidence. And they'll typically ask you, like, what's the constitutional problem with admitting a statement? And a lot of people will say, oh, it's, hearsay, or they'll go into an evidence analysis when they want you to talk about the confrontation clause if they're talking about a constitutional problem. So remember, in a criminal case, if evidence is testimonial, the declarant's unavailable, and the defendant had no prior opportunity to cross-examine the declarant, the statement cannot be admitted, generally even if there's a hearsay exception. So keep this in mind. Review some of these essays that have tested this. It came up in February 2020 in the con law question, same with February 2018. And you can also see, I would look at the July 2012, 13, and 14 essays because they're a good representation of how the confrontation clause is tested. Okay, next, contracts. Pay close attention to the call to question and a contracts question. These are often long questions. Michigan distinctions are often not tested in contracts questions. There's honestly not that many Michigan distinctions. But the biggest mistake that we see people make, especially in recent exams, because the question's so long or because the call to question asks examinees to do so much, is a lot of people just miss issues. Typically, they like to test things like contract formation, modification. There's a lot of different issues that can come up in contracts questions. So the best thing you can do is, as always, review past essays. One thing I want to point out is that for contract formation, some people automatically start their essay with a half a page defining how contracts are formed. So they talk about, what's an offer, what's acceptance, what's consideration, blah, blah, blah. And they spend a long time on it, which is fine if contract formation is an issue. But if contract formation is not an issue, then don't spend as long talking about contract formation because it's literally not going to get you any points. I recently gave a speech in a Michigan bar exam essay grader was there. And the grader was talking about how they don't like to see fluff, okay? And this would be an example of what fluff is. If you just say something that's semi-relevant to the subject but not relevant at all to the fact pattern, you're going to kind of annoy the grader, and it's honestly not going to get you many points. So I would avoid having like a form paragraph that you put at the beginning of every essay, especially with something like contracts where people just waste a lot of time. I saw that happen a lot when we were reviewing essays for appeal for the February 2020 bar exam, where people would start their essays with something like this, and then literally like 5 issues were asked about, and some people would have really long paragraphs that just weren't relevant to what was being asked, and they would have picked up a lot more points if they paid more careful attention to the call to question. All right, sales. Article 2 of the Uniform Commercial Code. This hasn't been tested as much recently because usually sales is not tested if something like negotiable instruments or creditor's rights or secured transactions is tested. And because the board has been trying to get trickier with which subjects it tests, it's been leaving out sales and testing these instead. I would make sure that you know the UCC statute of frauds exceptions. I'd make sure you know things like delegation. These are pretty straightforward essays if you know Article 2 pretty well, which is, of course, the problem because it's kind of hard to learn Article 2. But keep that in mind when you're going through these essays. So you'll probably see a contracts question, but there's a decent chance that you won't see a sales question on the Michigan bar exam. Okay, the last subject I want to talk about is torts. Torts is generally tested on the Michigan bar exam. Occasionally, you will not see torts tested and no fault will be tested in its place. At least that's how they've done it in the past. The most common issues are negligence. They love to test premises liability and duty owed to an invitee. If you see this, remember to talk about duty, breach, cause, and harm. Connect all the dots for the grader. Look at some of these past essays. It's typically tested in a pretty standard way. Also, I would review governmental immunity, particularly if you're taking a commercial course that does not emphasize governmental immunity, because while this has not been tested by itself recently, it has been tested on and off on the Michigan bar exam. And even though it hasn't been tested itself in a torts essay recently, it's been referred to in many different essays on the Michigan bar exam. So remember, a government agency is generally immune from tort liability, and an agent is immune unless they're grossly negligent. Those are kind of like key takeaways, although that's just a very rough general idea of the law. I would look at some of these past essays as well as the Michigan Government Tort Liability Act if you're not familiar with it. And then lastly, assault and battery are two of their favorite intentional torts to test. You want to know these rules like the back of your hand. If they do test assault and battery, because it's technically easier, the grader will be harder on people. So you want to make sure you know this really well. They also like to test defamation. They've tested nuisance before. In February 2020, they most recently tested false imprisonment, which is kind of new because they haven't really done that. So keep in mind that assault and battery are their favorite intentional torts to test, but they've tested others as well. Okay, in the next section of this, we'll pick up with evidence.